Hello, government class. Good to see you guys again. We're in week 3, hard to believe, in our distance learning program. We're in lesson 6, discussing the judicial branch, and we are today getting ready to get into some more terms of the court, which we started last time. And I'm sorry to say, but this is not going to be one of the most exciting lectures. A lot of note taking for you as far as these different terms. And just to preface it by saying there is not a lot of, there is a lot of terms that we should be able to discuss, but we don't have the time to. So we're only hitting the highlights, dealing with the court system and expectations in court. So as soon as we get done with the terms of the court, then we're going to go to the people of the court, or important aspects of the courtroom, so things for you to keep in mind. So the 2 videos that I had you watch this week on Monday, hopefully those were an encouragement to you to be able to understand what goes on in case you have to go to court. Probably about half to 60% of you will end up in court someday for some reason or another. So it's good for you to have this terminology and understanding about it so that if you have to go, then you know. All right, so we're going to get into these terms. I'll try to give you a little bit of time to be able to take notes today. So we'll see how that goes. All right. Okay, so let's get to our first set of terms today. First one is a grand jury. All right. We talked about this when we were dealing with the impeachment trial, where the House of Representatives during the impeachment trial acted as a grand jury. The grand jury is a group of people who evaluate whether there's enough evidence against a person to order him or her to stand trial. So that's what the House of Representatives did during the impeachment process, is they acted as a grand jury to determine if there was enough evidence against President Trump to be able to take him to trial. And then when you get to trial, you have what we call a petite jury, a jury that decides an individual's innocent or guilt. Then it comes from our right as a trial by jury. Okay, so that's called a petite jury. And remember, during any time, you can pause this, write down your notes, because you're supposed to be writing down your notes, and then you can continue it as we go to the next slide. All right, so those are the 2 types of jury, a grand jury and a petite jury. The next one is an arraignment. So these are different parts of a trial, and you saw this in the videos that you watched. An arraignment is the proceeding in which a defendant is brought to court, informed of his charges, and asked to plead guilty or not guilty. So this is the first thing that takes place, is that they're brought in, and they're brought into the courtroom with the lawyers present. They plead guilty or not guilty, and then they basically they're informed of the charges first, and then they plead guilty or not guilty. Now, I don't understand why there's a second step to this, but then there's a second step which deals with a pre-trial hearing, and that is where they set the date for the trial, and the legal teams hash out details of the trial. And then there's usually a third part. Sometimes they'll do it in the pre-trial hearing, but usually the third part is choosing the jury. And that's where they come together, and the jury is presented, and they're able to co-select members of the jury. So the arraignment is where they plead guilty or not guilty. The pre-trial hearing is where they set the trial date, and then they also kind of hash out the details of what evidence they're allowed to bring in and what they're not allowed to bring in. And then the next term here is a deposition, and this is where a witness, testimony of a witness other than in open court. So in other words, they didn't get up and sit on the stand. They actually gave it, usually in the form of an oral testimony, and then an official of the court who could administer an oath, because they have to administer an oath saying that this is truth and nothing but the truth. And so when they do that, they're able to write this down, and then the person will sign it. Sometimes the person writes it out, but usually someone else writes it out or types it out for them. The person reads through it, agrees with it, and then they sign it saying, this is my word, this is my testimony. So that's a deposition, and that can be submitted in trial, and then that person never has to sit on the witness stand. Okay? Oh, don't get overwhelmed. I know this is a lot. Okay? The next one is an exclusionary rule. And the exclusionary rule goes along with the rights of the accused from the Bill of Rights. So it prohibits evidence obtained without a proper search warrant from being used in a trial. dealing with the Miranda rights as well as far as what you say. So what you say as far as testimony or what evidence has to be procured in an appropriate legal way. And so if it is not, it's excluded from the trial. And a lot of people have gotten off who were guilty because things were done illegally, getting them to court or getting the evidence against them. The next one is you got to understand the difference between a subpoena and a summons. Okay? So a subpoena basically is a writ, and that's an official word coming from someone, an official order. Ordering a person to attend court, issued by a government agency to compel witness or evidence. So this would be like in a criminal trial that you had been subpoenaed to be able to testify. Okay, and a summons is an order to appear before a judge or a magistrate. And it's a legal document and it comes from the court or an administrative agency for various purposes. So it doesn't just mean that you're a witness. It could be, if you were summoned, it could be for several different things. But a subpoena comes from the government, whereas summons comes from the court. That's the main difference between the two. And also the subpoena basically means that you're coming in to give evidence or to be a witness. All right? So that's the difference between those two, a subpoena and a summons. But if you get either one, you're required by law to report. Okay? And the next one is an affidavit. An affidavit is a written statement confirmed by oath for use of evidence in court. It kind of goes along too with the idea of a deposition. But an affidavit can be from the person who is standing trial or someone else who is a part of the trial, and it can be used as evidence in court because it's a sworn statement. It's a statement given by oath. So if you come back later on and say either the deposition or the affidavit was you lied, then you've committed perjury, which is lying under oath. Okay? So those are those. Next set, habeas corpus. Okay, this was actually in the Constitution, and we know that the Latin phrase habeas corpus means you have to produce the body. In other words, there has to be evidence to hold someone. You've all seen this. We can only hold them for 48 hours until we charge them. There has to be something without doubt that there has to be something, a charge brought against them, that you have actual physical evidence or two witnesses. So a court order demanding that a public official deliver an imprisoned individual to the court and showed valid reason. This can be at the arraignment as well. Valid reason for the person's detention. If you're going to hold this person, you have to have something physical. Where's the body? Where's the evidence? Where's the testimony? Okay, so that's habeas corpus. That's one of the things that we have to protect us, so they can't hold us for a long period of time. It's one of our rights here in America, where they can't hold us for a long period of time without evidence against us. Okay, next one is a bench warrant. You see this in our newspaper that people have been issued a bench warrant, and that's basically by a judge commanding someone to appear in court because they they failed to obey a court order. Like they didn't pay a ticket, they didn't show up to defend their ticket. They didn't show up for a hearing when they were supposed to. You can actually get a bench warrant sometimes if you didn't show up for jury duty. And it doesn't happen very often, but they do it sometimes. All right. So the next one is a recusal. And this is something that's a voluntary action from a judge or a lawyer or a prosecutor to remove themselves presiding in a case because of bias or conflict of interest. You can also be recused as a juror. So if you are a relative or you have family members on the police force and so on and so forth, and you have a lot of connections to the case, you can recuse yourself, or the lawyers can recuse you to be removed from that case because of conflict of interest or a bias. Okay? And then these next three deal with the Supreme Court. Okay? And they're basically dealing with the majority opinion, the dissenting opinion, and the concurring opinion. Now, this is something that happened during John Marshall. Okay? So let's say there's an issue that comes on to the Supreme Court, and they come out with a 5-4 decision. So there is a majority opinion. The majority opinion would be the 5. All right? That's the opinion that wins. So 5-4, even though it was close, all right, it was almost a split, the majority opinion wins, and that's the court stand on the issue. So what happens is the view of the Supreme Court justice who agree with a particular ruling, and it's written by the most senior justice in that opinion. So only one comes out, okay? Though there were 5 who voted for it, one of them writes the majority opinion. And they say, this is what we agree with, all right? Then one of the things that John Marshall thought was fair is you would be able to have a dissenting opinion. Why were the 4 dissenting? So, Supreme Court opinion by one or more of the justices in the minority who oppose the ruling. Were against this ruling. And the most senior justice on the losing side decides who will write the opinion. So they choose someone to say, this is what the reasons why we dissented. So when you lose a case in the Supreme Court or win a case, you find out the majority opinion and the losing opinion. And then they also allow what we call concurring opinions. And a concurring opinion means a Supreme Court opinion by one or more justices who agree with the majority's conclusion. So the majority, not the dissenting. Dissenting only gets 1. But a concurring opinion can be, all right, we agreed with this decision, and yeah, we agree with the overall idea of the majority opinion, but there's another reason too, and we want this to be explained. That's what a concurring opinion is. And you're able to explain that. And sometimes these are like 5 or 6 pages. They could be 20, 25 pages long. And each of the judges are selected to be able to write these things. Now, concurring opinion is basically a judge saying, I want to write this too. I want it to go along with the majority opinion so that people know that there are multiple reasons why this was passed, not just the 1 or the 2 that is mentioned in the majority opinion. Okay? All right, so that concludes our lesson for today. These are some of the terms. Now, when we talk about jury duty and things of that nature in a couple of lessons from now, then we'll get a few more terms. All right, but that's basically the terms. Next time, on the next lesson, lesson 7, we will be getting to people of the court. Okay? All right. There's also a video connected with this, 2 videos that I want you to watch. It kind of gives you a closing argument in a courtroom scene. We're going to be watching some of those as we go through here. Just giving you a little bit of idea, but it's from that movie. I think it's called Just Mercy. Really good. And it shows you about what the law is all about and what justice. So enjoy those clips. And today, all you have to do is take the notes, answer the little quiz questions, and you'll be done. All right, Lord bless you. We'll talk to you later.